afternoon, everyone. And I'd just like to start by saying thank you to Kamla and the CCGI for the opportunity to make this presentation today. Let me start by saying that when I was asked to participate in this presentation, I thought to myself, wow, this is a very broad area in terms of compliance, especially with respect to private companies. And how can I set out to try to do justice to this area and this topic within the timeline that we have set out today? So I'm just going to start by looking at where compliance sits in the overall framework. As many of us may already be familiar with that GRC trio, or the governance, risk, and compliance elements. Because after all, this is CCGI, and it is, looking at the impacts in terms of governance as well. Okay, so looking at the diagram that we have here, looking at the relationship between governance, risk, and compliance, we see the importance of these three areas. And, there's this discussion as to whether one is a subset of the other, what exactly is the relationship between the three. And when we look at them, we realize that they all serve their individual purpose, but they are all very significant to the business, and they are all very much interconnected. And if we start with governance, which is the rules, the processes, and the policies that steer the organization to achieve its goals, and we then look at the risk in terms of the risk management, which might be the events that impact negatively on the organization on a day-to-day, and how do we mitigate and monitor that risk? It takes us down to compliance, which would be the steps that the company takes to meet its standards and regulations and to really run safely and, most importantly, legally. And then if we look at that relationship even further, in order to be compliant, we then have to develop rules, policies, processes, and have those things in place in order to provide guidance to our team. And having those things in place creates the risk management framework by which the organization needs to operate and to manage its risk. So here we see the relationship between these areas, and really it sort of sets the tone in terms of where compliance is and what compliance requirements we would have. So what do we comply with? Depending on where you are, private, public, within the financial industry, wow, there's a slew of things. There might be standards depending on what sector within the private sector you are in. There's regulations, we have policies, we have rules, we have perhaps internal requirements, and most importantly, we have the various pieces of legislation that may be applicable to our area of business. But then what do we comply with? And again, depending on your business sector, you have several areas that you certainly have to comply with. To the very top, of course, we have our statutory and regulatory requirements. And every business, regardless of what sector you are in, the Companies Act, the Income Tax Act, National Insurance, OSH, industrial relations, depending on the size and scope of your business. And now we are seeing anti-money laundering and counter-financing of terrorism seeping its way, not just within the financial industries, but also into that area of listed business where we have private companies in the form of motor vehicle sales, accountants, and attorneys. And those Proceeds of Crime Act, or whatever your government legislation might be in your respective jurisdiction with respect to anti-money laundering, that opens a whole other area in terms of requirements and compliance. You may also have standards and codes, International Organization of Standards, the ISO standards, other national standard setting bodies, again, depending on your area of operations, international financial reporting standards for your reporting, your financial statement reporting, and you have health and safety. So there are a series of statutory, regulatory standards and codes, some of which you might not be able to say or deem them as discretionary. They are things that you must comply with as part of your business. Then, as we go down the pecking order, you have contracts, you have agreements. So you may have partnership agreements, depending on the nature of your organization. You may have shareholders agreements, which determine how certain transactions, certain processes within the business must be done or must be facilitated. You may have significant transactions, again, depending on your area of business. You will have vendor service provider agreements as well, all of which must be taken into account, perhaps before you enter into certain types of transactions, related or connected transactions. Then we can probably combine policies, processes, and procedures, as those may be internal in terms of what the organization has set out in order to ensure that we treat with these requirements as stated above. But they really inform how things should be done and by whom. And we'll go into this a little later on the role of compliance and the importance of the how and the why, very importantly, indicating to your team the why. Because you don't want the statutory and regulatory requirements to only be with your regulatory manager or your legal counsel. Everyone, depending on what they do, they ought to know why and how it impacts the organization if they don't do it in a particular way or within the stipulated manner or time frame. And then we have controls, critical and important aspect of a business that evolves as the business evolves. So when we look at the compliance framework and you speak about the risk assessment and so on, you then have the controls that must be in place to ensure that you address new and evolving risks that may impact the business. Next, we look at the compliance framework. And what I tried to do more and more as I looked at this model, a lot of the areas sort of hit me directly with respect to the principles of governance. And more and more you were able to see what certain areas of this model and how they correspond to governance. And again, looking at that sort of overlap in terms of the GRC. And when we look at governance, starting in terms of the tone from the top, that to me has always been one of the most important and critical areas. The board, those charged with governance and responsibility, they are the ones that must indicate what is the acceptable culture, what is the acceptable, what represents the company. So they must engender that trust and encourage that culture of compliance. They must set the standard for the organization in terms of what is acceptable and more of a willingness to comply rather than a nuisance in terms of saying, oh, well, we have this requirement, let us just check this box and move on, right? When we look at the risk assessment, it is very important. And a lot of these things, they may sound as though, well, they only belong in large organizations, but let's be clear, these things can be scaled for any size of organization. It just, you really have to understand the underlying concept of what it is you are trying to address and treat with. So this risk assessment really assesses where you are as a company in terms of your gaps and helps you to identify where you would like to be in terms of what is acceptable in terms of compliance. Are we meeting all of our requirements? If not, why? Is it presenting an unnecessary risk? Do we have to keep looking at whether we are going to be audited by the PIR because we're not filing, because the calculations are not correct? What exactly, is our appetite and our tolerance with respect to our risk? And then coming from that exercise, you have your policies and procedures, which must guide the organization to define, as I said, the who, the what, the where, the why. Clearly articulate to your team, the wider team, who are responsible for actually executing on the responsibilities. Why do they have to do it? Someone may be required to file something with the registrar within 15 days. They might not be aware that there's a requirement for 15 days, so they may say, okay, when they get to it. So it is very important that we have these policies and procedures to aid the compliance framework in setting out the instructions of what ought to be done. And again, this is an evolving process because you don't write a policy today and it remains in place for 10 years or 5 years. More often than not, especially over the last couple of years, we've seen so many changes. You have to review these documents and make sure that they are current and they address the current risk. Training is another area, and I know it can be problematic because it is time consuming, or in some cases it might be costly, but I cannot overemphasize. It's something that I have seen certainly in my own organization. Training is key. It is not just enough to give somebody a policy and say, here, when you want something, go, you can find it on the intranet here. Training is a key part of ensuring that people understand what their responsibilities are under the policies and procedures as set out. We spoke about the controls that are important to make sure that we address any risk that may be posed to the organization. We have the monitoring and reporting, the system of reporting and of monitoring and reporting to those charged with responsibility. And it really seeks to address, are we doing what we ought to be doing? And it should be encouraging that accountability, that transparency in terms of what is being done versus what is expected of us. And of course, third-party management may or may not apply depending on the nature of your business. But if it is that you do have external stakeholders who from time to time would conduct reviews of your business and the way that you conduct your business, that would certainly be a critical element. So is compliance really important? Is it really that important? And how do we, how do we look at it, and how can we address, what it means to us in our various sectors and organizations? So first of all, compliance is part of your organization's duties to your community and your stakeholders. And that reason is very basic. If you run a business, whether for profit or not for profit, you benefit from the community's basic service in one way or the other. You owe a duty to comply with the law. Further, if you use resources from investors, creditors, you need to be able to assure them that you are, regulating the conduct of your employees and that you are complying with whatever the rules and the laws are in your jurisdiction. And one might see, in terms of non-profit organizations, one might think, okay, we are small, we don't really have that much, and they may focus on the fact that what they are doing is good for the environment, good for the community, but they also have to understand that they have a responsibility of complying with the law under that umbrella of their responsibility to the community as well, right? So that is an aspect of risk that they need to make sure that they too adhere to, and it is not just about the companies that are for profit. Without a compliance function, you cannot reliably build or maintain trust with others. And trust is fostered through our repeated interactions with someone, whether we've had honest communication with them, following through on commitments. Organizations must ensure that they are meeting those requirements. And how do they do that? Codes of business conduct, those tend to be the most common. Setting out compliance manuals in terms of how persons ought to behave in terms of representing the company, representing their brand. If you have no compliance function, you could be inviting reputational damage or reputational risk. And this is something that Kamala alluded to in her introduction. So in Warren Buffett, he would have indicated that, it takes 20 years to build a reputation, about 5 minutes to lose one. So, and it really is that easy. Someone just needs to have one interaction with you, which goes off course, and that's it, you're written off, right? But it's no surprise. And it's no surprise that I think leaders within the business community They would consistently rank reputational risk as a number one worry. And if you're not trusted in the marketplace, clients are unlikely to work with you. And on the other hand, if you're doing the right things and you do have that trust, clients will give you the benefits of the doubt. So understanding that a strong compliance function helps the organization in terms of building that and assisting with risk management in that area is very, very critical. So as I indicated in my prior slide, compliance helps to define an organization's why and its how. So we do tend to focus on what we do, how we do, why we do. I always like to tell our people, do you understand why? Do you understand why you are doing what you are doing? If you have to settle a client within 3 days of a trade, do you understand why? This is not just the organization saying to you, this is our policy, it's 3 days. If you don't make it in time, you can pay them on the 4th day. No, everybody has to understand, okay, it might be the rule of the stock exchange that you need to settle, you must settle a client within this time frame. So by making sure that those who are actually doing the action are aware of the why, they understand how important their role is in making sure that we comply. And in my case, where you work in an environment which is so heavily regulated, you have audits coming at you from every point, from every regulator. There is constant scrutiny of your adherence to these requirements. So the why of the organization, obviously it drives and it motivates the efforts because it helps people to understand better. And I believe people work better understanding why they're doing what they're doing. The how, compliance focuses on what behaviors will and won't be permitted in the execution of the why. So we tell you how, right? Many people consider compliance as an exercise in saying no. Those in charge of the rules enforce those rules to prohibit behavior. Anything you ask compliance is no, or is this high threshold that, it's a hard sell. How do we, But that's a misconception. And if that's the way your compliance function is operating, you really need to look at that and see whether it is harming the organization or whether it is helping the organization. And I say that because compliance is supposed to increase the efficiency and effectiveness of the employees once they are trained to understand how to do their jobs and how to reason with ambiguous situations. So compliance helps to generate actually yeses. It should aim for yeses intuitively, as opposed to just generating a no. So point number 6, compliance can serve as a driver of change and innovation. And some people, again, view compliance as being inherently conservative. They think that the purpose is, again, to rein in conduct, what you're doing, you're not supposed to be doing that. Instead, it can be a very powerful tool to help in terms of change, long-term change for the organization. Behavior stems from training, of course, everything I said before, code of business conduct, values, and making that information available. But ultimately, it can help you in terms of communicating and charting out what those values are, where you want the organization to go. So it can be a driver of change. Number 7, compliance enhances consistency. So again, without a compliance function, you find decisions can be ad hoc and they can be made in a vacuum. So you want to know something, you don't have a compliance function, you may go to person X on this given day, they will tell you do this. On another day, person X might not be here, you go to person Y, they tell you something different. And so you have a series of uncertainty that is created. What you want to make sure is that there is consistency. And Peter Drucker explained that all events, but they're truly unique, require a generic solution. They require a rule, a policy, a principle. And once the right principle has been developed, all manifestations of the same generic situation can be handled pragmatically. So It is not about reinventing the wheel every time. And once you are able to provide that consistency and that guidance, persons ought to be able to understand how to manage those situations. And therefore, it helps to empower the organization as well. Compliance can reduce unforced errors. So it is an important risk management tool, as we've clearly seen so far. And some of the most common risks to organizational performance and compliance would be unforced errors. And how can we look at that? And again, a healthy compliance function can help make any organizational waste visible by tracking, looking at the metrics. Again, in your framework, you would have identified where you are, where you would want to be. Your reporting and monitoring would help to identify to you where you have gaps and how you can do things better. And that is the way your compliance framework and function ought to operate. So what can we expect? Well, I know on my end it's not getting any easier, and I think for him it doesn't look like it's getting any easier either. I don't know that anybody out there is facing less regulation or less requirements or less of anything related to compliance. So what has been some of the challenges that we face with respect to ensuring compliance? Well, at the top of the list for most organizations will be that increased cost of compliance. If you didn't have a compliance officer before or somebody in that similar capacity, you might find that you need to have somebody now. And as your business grows from time to time, and depending on where you are, you may need more than one resource. And then not just in terms of the resource, but everything that follows in terms of all of the points here would have some cost implication attached to them. So when we look at technology to support compliance, so that's the other thing. When you go to management and you say, listen, we need to have a system that helps us to do this. We need to have perhaps an API that helps us to, to deal with this risk that we see. We have this new regulatory reporting, or we have this new information we need to provide to this contractor. So therefore, we need to be able to have a way to pull this information easier, or a way that provides the reporting in an easier format. And then everything that we talked about, again, prior, looking at the monitoring, the reporting, the metrics to help compliance be able to give valuable feedback to the board. Certainly, the use of technology will be instrumental there. And of course, limited resources really does the challenge. I mean, not wanting to use the technology is not a challenge. The limited resources by the organizations to help us access that technology usually tends to be the challenge. Additional resources, as we said, with respect to sufficient technical expertise. So depending on your sector, I belong to the financial industry. We have legislation that changes. It feels like every year because there's always something that's new and evolving. And then when you have changes to legislation via the miscellaneous provisions, it makes it a little harder to pull all the pieces together to see what has changed. However, my point is, you need to make sure that you have adequate resources with sufficient technical expertise to advise your board and senior management of these impending risks. You cannot wait for a breach of contract. You cannot wait for a breach of legislation, then to find out, oh, we were supposed to be doing this. You always have to be proactive. That has been my experience, and seeing, in my case, seeing the securities sector evolve over the years, that is certainly the learning. You cannot say to the regulator, well, I didn't know, or I thought this was the case. You have to make sure that you are on top of anything that is in draft, anything that could potentially impact you. You need to make sure that it is there up front and center, it is there for the board to see so that they can take the appropriate action. Continuous training, again, as I said, goes without saying. It is not for the regulatory person, it's not for the legal person, it's not for the board members. It's not enough for them alone to know what is required. As things change, you need to let those who are the ones executing, the ones that are actually doing the job, they need to know what is coming down the pipeline, and they need to know how to adjust. Continuous and dedicated focus on developing and maintaining policies and procedures. Again, I mentioned this point. You don't just create the policies and leave them there. You need to continuously review. It takes time, it takes effort. You don't just go and tap a finger on a policy, everything from your head is transferred to the document. It takes time to review, to refine, to make sure that you've looked at all the areas. But again, it's a very important part of the mix. And to remain competitive, companies must understand the cost of doing business the right way. Looking at cutting corners is not going to work out, whether in the medium term or the long term. Doing business the right way is a very critical aspect, and they need to balance that with the risks involved with non-compliance. So you can tell yourself, listen, it's too expensive to have this. You have to weigh it against, if I don't do it and I run afoul of whatever my obligations are, what then? How does that weigh up? And it's not just a dollar, it's not just a dollar amount, it's not just the amount of a fine, it's not just the amount of a penalty, it's not just the amount of, as we'll see later on, it's not just the amount of maybe a lawsuit or what you can win or what you can't win. It's much greater than that, because we identified reputational risk as being right up there at the top. And for me, when I think about compliance, compliance provides protection. At least that's what it aims to do. And under here, it should really have the company, it should really have the directors, it should really have the officers, it should have everybody else, the shareholders, the stakeholders of the company, because that's really why you're doing all these things that you're doing. It is to protect, it is to make sure that, as I said, you're doing business the right way. Because if you do that, you don't have to keep looking behind your back to see, what is coming. You would like to make sure as far as possible you're doing the right thing. And if that is what you're doing, there's nothing to worry about. And you can focus, as Kamla said, on the performance of the business and understanding that, that is where we want to go. And the two should be in harmony together. So in conclusion, Kamla already, I think, kind of stole this slide, but the consequences, I think we all know. Financial losses, certainly penalties, depending on your area or your operating segment. Business disruptions, certainly some businesses can be shut down. When you think about OSH, when you think about, those are things that have far-reaching implications, where financial loss is just a small segment when you think about business disruptions. Reputational risk and that erosion of trust, depending again on the segment. Financial services is key. Reputational risk is very, very high. Legal risk, possible lawsuits, civil liability. And when you look at imprisonment as well, criminal liability. And I think back to, we had amendments to our Companies Act maybe it's about 3 years. And I know CCGI was upfront. They did quite a lot of good work with respect to helping people to understand what those changes meant, because Companies Act changes to that act affected everybody. Forget, whether you're part of the big banks, the more sophisticated companies, because I myself, when I had gone to companies registrar, I saw people who were part of the small businesses, mom and pop shop, etc., coming to the counter and saying they don't understand what is a beneficial owner. What do you mean by this? What do I have to put here? That is why it is very important that regardless of the size, scale, scope, etc., whatever relates to your business, it is a critical part. So if your business is, maybe it's construction, it's not just about being an engineer. And that's not what it takes alone to having a successful business. It also takes the support of all of the things required to ensure compliance in order for you to focus on the performance and the income generating segments. So that brings us to the end of my presentation. Kamla, thank you all very much for the opportunity. I hope I did well in terms of time.
Thank you very much, Aleema. I think you did very well and you gave us a really excellent start to today. In particular, I will tell you, I like that slide where you went through the importance of compliance. And I think for all of us, the fact that compliance can serve as a driver for change and innovation was an excellent point. To also see that it can ensure consistency in the way the organization runs and the fact that you could reduce unforced errors. Those were some excellent points that should underscore the need for why organizations must focus on their compliance. And of course, ensuring that there's ongoing training, that ties directly into why we are here. And I'm so happy you referred to the amendment to the Companies Act with respect to beneficial ownership. I think there may be a need for us to revisit that topic again, because a lot of persons are trying to ensure compliance with that, and there are some issues involved. All right, so thank you, Aleema. I couldn't have asked for a better start to today's session. That was a job well done. Okay, so now we move on to the chairman and the procurement regulator at the Office of Procurement Regulation, Mr. Moonilal Lalchan. I know I should tell you, Mr. Lalchan, the majority of persons who are here in the room with us now are in private sector organizations. We do have a few who are with state enterprises, but the majority here are persons who would be wanting to hear and clarify, what are some of those compliance requirements that they need to ensure that they are meeting the new procurement regulation. So I am now handing over the session to you.
Good afternoon to all, and I concur with your observation, Kamla. The presentation by Aleema was really insightful. In fact, I'm going to quote some of what she would have said in support of my presentation. So she gives me a good segue into my presentation, actually. So once again, I'm very happy to be part of the presentation to the Caribbean Corporate Governance Institute. And really, this afternoon, we will specifically look at some of the issues that will be faced by the public and especially the private sector in terms of what will be taking place now and in the future in terms of full proclamation of the Act. So we'll get straight into the presentation. I always like to set the context in terms of what we're trying to achieve by the Office of Procurement Regulation. And some studies were done in 2014 by the Organization for Economic Cooperation and Development that suggested that public procurement is one of the government's activities most vulnerable to corruption. And it's just due to the volume and magnitude of the transaction that takes place within this environment. And if done correctly, between 10 and 30% could be saved. And what we did is actually look at the national budget. And basically, the national budget is about 52 billion a year. And we suggested that about 50% of that is spent on procurement activities, which gives us a figure about about $26 billion dollars. And if it's $26 billion we're dealing with, if we can save about 20% of that on an annual basis, we can potentially save about $5.2 billion. And think what that can do in terms of running this country, the medicines, the actual roads, repairs, etc., etc. So that's one of the data points we like to use. The second data point is in respect of what was done at the European Commission. The European Commission suggested in their study that over 120 billion euros are lost every year because of corruption. And basically, almost 50%, that little blue semicircle underneath the pie chart there suggests that 50% is just due to the lack of adequate capability and management of the procurement function. So those two data points there kind of sets us up. Additionally, the Prime Minister on January 13th would have suggested that digitization could alleviate some of the corrupt practices and so on in the public sector, where it is flourishing with impunity. And in addition to that, the Archbishop of Port of Spain on July the 10th would have indicated that corruption runs right through the country, and you can't get justice at any level of this country. At no level you can get justice, corruption at every level. So that kind of puts you in kind of framework as to what we're dealing with in the country in terms of public procurement. So who is the OPR? The Office of Procurement Regulation is established by the Public Procurement and Disposal of Public Property Act 2015 as amended. We are a regulatory body with an independent board appointed by the President of the country after consultation with the Prime Minister and Leader of the Opposition. We are an independent organization that was made clear in Section 13(2)(b) of the Act. And it says that we shall not be subject to the direction or control of any other person or authority in the performance of the function, but shall be accountable to the Parliament. So that's the OPR. Aleema would have touched on some of these, and in her discussion in terms of compliance, and she would have mentioned accountability, transparency, and fairness, among others. Here it is, the similar type approach is taking place at the procurement level, and this is contained in the objects of the Act in Section 5. She also mentioned a keyword, principles. Really, it's to promote the principles of accountability, integrity, transparency, and value for money. That was stated in the preamble to the Act. But it goes on to speak to things like efficiency, fairness, equity, public confidence, local industry development, and I'm sure some of the local suppliers and contractors will be very happy in terms of the local industry development, and we can explore that further in the presentation or in the question and answer. Sustainable procurement and sustainable development. Now, as you look at the principles, one of the things that you will probably see very quickly is that they may be in conflict with one another. For example, you may want to have sustainable procurement and sustainable development, but that may lead to some erosion in terms of the cost of doing business, and that may impinge on the value for money principles. So is it or is it not? And that's a question that I'm sure we want to answer before we finish the session today. Not necessarily, because the cost to the environment might be much more than having sustainable procurement and sustainable development. So some of the things that we at the office were empowered to do is to establish a comprehensive database of tenders and awarded contracts. So going forward, all contracts and tenders that have been awarded to private organizations or even public organizations has to be now declared on a quarterly basis and made public, so that we will now know who the contract is awarded to, how much it was awarded, if there are any variation order or litigation matters associated with those. So that's something that you can look forward to. We have to suppose to set training standards, competency levels, and certification requirements. Now you are required to have competent and certified persons to do your procurement activities at the public sector, and to issue guidelines on the retention and disposal of public property. Those are guidelines that we have already issued. To prepare model handbooks with standardized bidding documents, to promote the use of technology in procurement and disposal. All three of those you'll have to be aware of, and we have issued guidelines. We have 44 guidelines already on our system. So private enterprises and public needs to be aware of those handbooks and guidelines to make sure that you're operating within those guidelines, you're in compliance with. Also to harmonize policies and systems and practices. What we find happening is that as many as you have public bodies, the 400 odd public bodies that we have looked at, everyone has their own policies, systems, and practices. So we are going to make sure that all that come together so that the practices are similar to each other. And to promote the public awareness, this is what we are doing today and we have done in the past, to review practices and delivery system on an annual basis. This is about continuous improvement, and we will continue to do that. One of the things that we would have asked to be removed from the act, from under our purview, is to act for the state to dispose of real property, because we thought that good practice would not allow us to actually dispose of state real estate and property and then come back and audit the same disposal. So we suggested that another organization within the state sector do that, and that was approved, and to advise on best practice to obtain value for money. The last two, which are very important, so you understand that we have the powers to audit and review systems of procurement and disposal to ensure compliance with the objects of the Act, and also to investigate any potential breach or alleged breach or suspected breach of the Act. And those will definitely lead to serious consequences in terms of things like bid rigging that carries a fine of $5 million and 10 years in prison. The failure to keep proper records during an investigation could lead to 5 million and 10 years in prison. Things like bid rigging, if public and private partnership organizations are involved in bid rigging, they both can face those fines and penalties. So you have to be aware of that. You need to make sure that you operate within the guidelines of the Act. Here is where I think a lot of discussion may take place later on. Under regulations now, in respect of pre-qualification and pre-selection, Regulation 8 states that public bodies are now mandated to only use suppliers and contractors that are registered and qualified as pre-qualified suppliers and contractors on the OPR database. So you cannot have your own list of pre-qualified contractors as a public body. There is only one list that will be used for accessing suppliers and contractors, and that will be held by the OPR. The public body will have access to do the pre-qualification, but it will be held at the OPR, and that database is already active. We have over 1,000 suppliers and contractors already registered and pre-registered, waiting for the full proclamation so that they can be pre-qualified. Upon full proclamation, there will be a 6 months period in which the suppliers and contractors will have to be pre-qualified. And after that, these public bodies will not be able to use their existing list of pre-qualified contractors. It will automatically switch over to the one held by the OPR. It is accessible to the public. The suppliers or contractors who submits information to the procurement depository shall be responsible for ensuring its accuracy. So suppliers and contractors, you need to make sure that whatever is put in that depository is accurate and no fraudulent documents are uploaded. That could lead to serious consequences of being knocked off the depository for a period of up to 10 years, and you would not be able to do business with any public body in Trinidad and Tobago. Of course, in conducting the due diligence during an active tender, public bodies now could require the suppliers and contractors who have submitted information to the depository to confirm that the information is accurate as submitted. So you have to do a lot of due diligence as a supplier and contractor. Whoever you give the responsibility to upload that information, make sure that they are closely managed. So pre-qualification really is a procedure to identify prior to solicitation the suppliers and contractors. I think most people will be aware of that definition. But what is pre-selection? It is a procedure to identify prior to solicitation a limited number of suppliers or contractors who best meets the qualification criteria for the procurement concern. So in other words, if you have 100 pre-qualified suppliers and contractors, a public body can identify the methodology that they will use to pre-select from that 100 and limit it to, let's say, 10 or 15. And you must state that clearly as to what you have used to pre-select from the list of pre-qualified contractors. And those guidelines are for pre-qualification and pre-selection, and the depository can be accessed through those links. So what are some of the documents and so on that you are required to present to the OPR? And again, you have to be in compliance with these, otherwise it will just delay your pre-qualification and may result in you being not pre-qualified. And it's broken down into categories and general information. All these you will find on the website. Legal requirements for things like insurance, legal issues that you would have been faced with in the past. license, permits, professional bodies that you are part of, bankers' letters or management accounts, audited financial statement, names of key staff positions, number of years experience, CVs, the qualification, all those have to be uploaded and be accurate. If you have to fulfill certain industry standards like store certification, OSHA, and recordable accidents and incidents, HSE policy, risk management system, quality control system, all those are now required depending on the level of participation, because we are now categorizing it by value categories. So the higher up the value chain you go, is the more information you have to provide for the office. For example, up to 100,000, all you need is a banker's letters. Over 100,000 and 2 million, you need management accounts for 3 years signed by 2 directors. Or if you are sole proprietor, by the proprietor. Anything above $2 million, you are required to have 3 years of audited financial statements. And if there are any obligation you would have failed to meet, you have to state those also. I deliberately did not go into the category and general information on number 1, but those are things that are standard in any pre-qualification listing. So here is what I want to place some more emphasis on. These are the things that you need to be aware of. Aleema would have mentioned some of it. A procuring entity shall ensure, so the public body who is doing the pre-qualification must ensure that the supplier and contractor have the legal capacity to enter into the procurement contract. They are not insolvent, in receivership, bankrupt, or being wound up. Their affairs are not being administered by a court or a judicial officer. Their business activities have not been suspended, and they are not the subject of legal proceedings for any of the foregoing. They have not, and their directors or officers have not been convicted of any criminal offense. You see that in red. There's a reason why it's in red. If we would have continued with that provision or requirement, a lot of persons would have been debarred from doing business with the public bodies. So we asked for an amendment to that part of the act, and that was amended by Act number 27 of 2020. So it reads like now, have not been convicted within the last 10 years of corruption or fraud-related offenses, legally or locally or internationally, as individuals or as directors or officers of a company. So if you're an officer or director, you know that you were convicted of those offenses, did not state it when you became an officer, an employee, and it is found out after the fact that the company is registered and an employee or officer has been convicted, you can be debarred from doing business for a period of 10 years. So you need to be very careful as to making sure that there's some declaration that is signed by your officers and directors in terms of that provision under C. You have to have fulfilled your obligation to pay all required taxes and contributions in Trinidad and Tobago. That's very important. If you have not paid your taxes, NIS and so on, you will not be allowed to be pre-qualified. Fact is, you are benefiting from public money and therefore you should discharge your obligations to pay the required taxes when due. You have the necessary professional and technical qualification and competencies, financial resources, equipment and other physical facilities, managerial capabilities, reliability, experience, and personnel to perform the procurement contract that you wish to get engaged in. Again, you have to have the internal mechanism to make sure that your professional and technical people are aware that they need to declare these things, and no false certification and so on has been conducted in the past. So it has to be authentic qualifications and professional affiliation with different professional like the engineering association, legal profession, and so on. They must be able to meet the relevant industry standards. So if you expect to do business in a live plant like PPGPL, you have to be store certified, you have to fulfill certain HSSE standards and so on. So all those are things that you have to certify and provide the necessary information. And there would be under section 29.3, no blight for any contractor and supplier. All these requirements shall apply equally to all suppliers and contractors. Standstill period is a requirement now whereby public bodies are required to have standstill period for their contracts and supplies of goods, works, and services. And what that means is that when you're going out for an active tender, you must state where there is a requirement for a standstill period. You cannot award the contract within the 10 to 15-day period unless you go through certain procedures. So I would not go through that in detail, but basically what it means is that you have an obligation now to explain to the unsuccessful suppliers and contractors the reason why they have not been successful, and also to indicate to them who you will be awarding the contract to and for how much. I mentioned previously, you can be made ineligible. Basically, there are 3 areas under which you can become ineligible from doing business with public bodies. First one, if you consistently fail to provide satisfactory performance. So you must be able to be on top of any requirements or making sure that you fulfill that requirement. For example, if you're a bad performer, you get notice of that deficiency and it is reported to probably your contractor or engineer on site, and that person fails to report it upwards. And consistently you get those bad reports and is not being brought to the attention of the persons that are in authority. You can find yourself being made ineligible for a period of up to 10 years for consistently failing to provide satisfactory performance. If you are found to be indulging in corrupt or fraudulent practices, you will be debarred from doing business for 10 years, not up to, but for 10 years. And if you're convicted of an offense under the Act, you will be debarred for 10 years. So it's important that you are on top of what is taking place. If one of your directors or officers have been convicted of fraudulent or corrupt practices, that needs to be made aware of to the organization. So you must have a mechanism in terms of your code of conduct and so on, and reporting those things. Because if it's found out, you will be debarred. And if you're convicted of an offense under the Act, of course, that will be a matter of fact. The contractor and suppliers will be given an opportunity to be heard and be represented by legal or other forms of representation during an active hearing for placing you on the ineligibility list. Now, who is placed on that list? The supplier contractor includes any person who is a director, manager, senior officer, partner, or other similar officer, or any person who purports to act in such a capacity. And senior officer has wide definition, as you can find, from managing director straight down to chief risk officer, and everybody in between could be debarred. Once you are debarred, you cannot now come through the back door, as they say, register a new company with new directors and expect to do business. Once it's found out that you were placed on the ineligibility list, you would not be able to come and register a new company or participate in a new company to do business. You will be debarred for the period as indicated under the Act. So the depository is broken up into different areas, and we have suppliers coming in to make requests for pre-qualification. The public bodies is included there because they are the ones who actually review all documentation and application to make the supplier pre-qualified. You have the system configuration in terms of workflow processes and so on associated with it. And then you have the reporting that you can run a number of reports in terms of who is pre-qualified in what area, what value categories, and so on. So all those are reporting things that the public bodies can access in doing business on the depository. So the supplier comes onto the system. They register and they get access to the system. And once you have access to the system now, you create your supplier record. And we would have mentioned some of those before, including your company information, your financial and legal information, safety, equipment, and technical competencies, and you upload all those documents. So once you upload all the documents, it's sitting down there in a holding capacity. If you believe that you have successfully submitted all your information, you then click the button and say, please pre-qualify me, or you make a request for pre-qualification. Once you do that, if you have selected that you did business with a present public body, it is automatically routed to that public body for reviewing your documentation and making you pre-qualified. If, however, you did not have an existing relationship with a public body, based on the UNSPSC code or your line of business code as recorded, once there is a match between your request on a line of business and a line of business that has been inputted by a public body, there is an automatic match and is forwarded to the public body for pre-qualification. The system is free of charge. You don't pay to get pre-qualified as previously you would have been required to do under the old system. It's open to everybody. You don't have to be a limited liability company. You can be a mom and pop operation, sole trader, individual, electrical contractor, plumbing contractor. They are all encouraged to be part of the supplier pre-qualification requirements. Once you publish your record, it is now published and open to the public bodies. You request your pre-qualification, as I said, by line of business, and you get pre-qualified. Once you're pre-qualified, you remain pre-qualified. So it's not an every 3-year occurrence where every 3 years you are required to pay how much thousands of dollars and get pre-qualified. And sometimes you pay your money and you don't even hear from the public body in terms of getting pre-qualified. We will be monitoring all the applications for pre-qualification and reasons for non-qualification. So once that is done, and of course, you keep your records up to date, you are required to, for example, the insurance certificate that we would have mentioned in a previous slide. You keep it up to date. And again, here is where compliance will be very important. 3 months before the expiration of that insurance certificate, the public body will get a notice indicating that your insurance certificate is about to expire. Within 1 month of the expiry, you get another reminder. And on the date of expiry, you get a final request to get the information up to date. And if you don't, on that last reminder, you are then knocked off the system. Once you keep those information up to date, you are not made ineligible. You remain as an active pre-qualified supplier and contractor on the database. It is broken up by regional corporation, so you could register by regional corporation, Tobago House of Assembly, CARICOM, and international. So those are the different areas. And the reason why we chose geographic location, because it helps in the pre-selection of contractors. For example, if you're looking for a small contractor that is doing business, let's say electrical or a plumbing contractor, and you want to engage in, say, let's say, Siparia Regional Corporation, you can then go in the system and pull out all the electrical and plumbing contractors within the Siparia Regional Corporation, and you can use that as a basis for pre-selection within a regional corporation. So that's how the system is geared towards pre-qualification. So that's about what I wanted to share and give you sufficient information to engage now in some discussion in terms of any questions that you may have, and we can have that discussion now. So Kamala, over and back to you.
Thank you so much, Mr. Lalchan. I think that that also was a very comprehensive presentation that should have helped all of us to know and understand the process as it currently obtains with the procurement office. Now, just to highlight, you indicated that no blight was going to be offered for any of the contractors or suppliers. Everyone is required to ensure that they comply with these requirements. And the fact that you have already started the process and you have over 1,000 companies and individuals, if they are sole traders and so, who would already have put in their information and everything is in place for you to go through whether in fact all the information and so meets the requirements. I was going to ask a question about how do we ensure that you can fulfill that requirement in terms of the providing satisfactory performance, but you did elaborate on that to say that if in fact the contractor would have been getting letters speaking to their performance and they don't do anything about it, that would be deemed a demonstration of failure to provide satisfactory performance, and then the consequence would be you can be debarred for 10 years. In that. So, and I also particularly appreciated this point which you reinforced to us as well, that the pre-qualification of persons in the system, when you looked at the senior officers, and so it's the individuals themselves who would be looked at. So if for any reason they're found to have been in breach, then they can't come back through a back door by now registering a new company and applying through that new company to pre-qualify again. So a number of really good information. Persons would also have been happy to learn about the fact that, you know, when the document is submitted to you, the process it goes through in order to have the qualification done, and the fact that all of that is permanent on the system as someone who is pre-qualified, unless they fail to keep certain critical information up to date. So very good information. So I have one question to start off the Q&A part today. And my question would be, the fact that there are some state agencies who have gone through a very elaborate process to have a system of pre-qualification for themselves. And, you know, and it's a very sophisticated system in the case of some state agencies. How does that now work with the requirement that contractors and service providers must register with the OPR and be pre-qualified on your system?
So that's a very good question, because that is something that has been raised by some of the public bodies, questioning whether or not, if one of the public bodies pre-qualifying some suppliers and contractors and they do not meet their requirements, why should they be forced to select from that listing? So that's one of the issues that will obviously come up. That's why it's now standardized, and the requirements is standard procurement practices in terms of pre-qualification. So what happens is that the documents that is required based on the value category are standard, and you have to comply with all the documentation. So for example, you may or may not have seen recently, the Water and Sewerage Authority would have issued a public invitation to all their suppliers and contractors. And you could well imagine WASA has real contractors in their portfolio. And they have required that all contractors come onto the OPR site and pre-qualify. Even though we don't have the mandate for full proclamation, at the end of this month, we will be opening up the system for full pre-qualification. So we're not waiting now for the full proclamation. We're going ahead, because we are having public bodies ask us for names of pre-qualified suppliers and contractors. In fact, we have 16 public bodies have already gone into the system and put in their information to compare with the 1,000. So what happens is that once you are pre-qualified with one public body, you are pre-qualified with all the public bodies, so that you don't go through different public bodies to be pre-qualified. So to answer the question that you pose, when you are putting in your information as a supplier and contractor and you select that I did business with the OPR, that automatically routes to the OPR, and the OPR pre-qualifies you. So if they have done business with Water and Sewerage Authority, T&Tech, let's say Heritage Petroleum, NGC, once they select one, it goes to, let's say, Heritage. Heritage pulls the information, you get pre-qualified, you are blocked from the other three. So the other three cannot pull that record. So you can't have parallel pre-qualification until the process is finished. And I believe we'll be given about 10, how much days, Ali?
Say about 10 days.
Yeah, we'll give about 10 days to complete that process. So after that 10 days, it is unlocked if the pre-qualification process is not completed. So you would have all the information at Heritage of all your existing contractors. So it makes life easier, because you already went through a procurement a process for pre-qualification. So when they come to you, you know this contractor, you know they have all the documents. So you do a very quick, you download all the documents, you know they are current, they are presently not debarred. So it makes life easier for the pre-qualification. So that's how we will use the existing list of pre-qualified contractors by public bodies.
Okay. Great. So I just want to let everyone know that we are now into the Q&A segment. So feel free to raise your hands if it is that you want to ask a question directly, or if you prefer, you can choose to put the question in the chat and we will bring it to the attention of our two presenters. So Mr. Moonilal, forgive me, but you know, a lot of the questions will be directed to the OPR because it's such a live thing for us now. So my follow-up question now will be in terms of those contracts which are currently out for bid and tender. You know, if they're private companies that are currently in a process with a state agency, would they be allowed to continue that process, or would you recommend that they continue but also register with OPR? What do you say to persons who most likely are going to enter into contractual arrangements with a state agency for provision of goods or services?
Well, it is mandated now under regulations that you must be pre-qualified. So the faster you get pre-qualified, and I can tell you, Kamla, we have some major contractors already pre-qualified. I won't call the names, but they are major contractors. We have a particular contractor from the Aleema district actually put in over 3,000 line of business. It happens to be a hardware to provide goods. So that's telling you the extent by which people have gone into the system. Some of the major construction firms are already on the system. So it is going to prove to be a challenge when we have full proclamation, if you don't get a head start, because you could imagine a whole host of these things will hit us one time. So that's why we started the process early. And at the same time, we were testing the system, and it's working very well so far. We have had very little complaints about getting onto the system.
Okay, excellent. So I see a hand up. That's Siron Bailey. Siron.
Good morning, Mr. Rampasab, Mr. Lalchan, Mr. Mohammed. My question and comment is to Mr. Lalchan. I just want to say that it is such good news to hear the new process to become pre-qualified through the OPR. Because having worked in a public body some years ago, it was extremely tiresome to go through the pre-qualification process. I'm sure some public bodies are actually very happy for this new process, right? I just have one question. Is there a particular time when you'll receive applications, or can we go on at any point in time throughout the year to become pre-qualified?
24/7, 365. So a contractor in Australia could access our system at any point in time. Remember, I mentioned we have done it by geographic location. So all the regional corporation, Tobago House of Assembly, CARICOM, and international. In fact, we did have sessions with all the regional corporation, with the THA, with CARICOM, and we also had it internationally, and we had several participants. So anybody, any part of the world could come in and put in their application for pre-qualification. So it's open 365. If we are done for maintenance, we just indicate on the website that we are done for maintenance for 3 to 5 hours and so on, and the time by under which we doing those maintenance.
Okay, thank you. So a follow-up question to that then would be these geographic locations. It is for persons to be able to register with you for provision of goods and services to Trinidad and Tobago? Or is it that our local suppliers can also register through the OPR, and there may be some mechanism that allows them to also be able to identify out in in CARICOM, for instance, if they can have access to provide goods and services?
Yes, they can do that. And one of the things about the new act, and I mentioned the whole issue of local content. Under the act now, it encourages development of local suppliers and contractors. For example, you have a preferential margin of preference. That's the correct word. You have a margin of preference for local suppliers. That gives you a 10% advantage over foreign suppliers. If you have certain conditions met, for example, you would have 65% of your local employment or 35% of value added in terms of manufacturing. Those are just two of the conditions. If you look at the one from Guyana, it's a lot more onerous. So we have simplified it really. And when you put together that and you satisfy those requirements, you automatically get a 10% uplift in the qualification for participating. So for example, you may be technically at the same level with the international competitor, and the cost may be higher than the international competitor, but not more than 10%, you will win out on the contract if you satisfy the requirement of the local content. So those are some of the advantages and the benefits for our local contractors in terms of their own development and to take charge of some of these opportunities.
And so in terms of filling the information to you now, there are some information that would remain valid throughout the life of the company, such as the general incorporation documents or so that you would require. But then would you recommend that companies provide to you full information such as their financial statements and stuff at this point, given that you have not yet had the full proclamation of the act?
Yeah, well, if they don't provide the information as required, and there are certain fields that are marked with an asterisk that is mandatory. So it's not everything is mandatory. So if you don't fulfill the requirements for the mandatory documentation, that will delay the process. So you need to put in all the information that is mandatory so that we will be able to move through very quickly in terms of the pre-qualification.
Okay, so the entire process right now is you are moving as though the proclamation is already there. So
Absolutely. Yeah.
Okay, okay. All right,
In
good.
fact, we have had requests for, as I mentioned, from public bodies, give us a list of names of persons who would have been asked to be registered in these areas. So we run the list and send it to them, and they're actually using those lists to invite suppliers and contractors. So this issue of non-proclamation or delay in proclamation, I could also tell you, Kamala, that we would have assisted over 1,000 requests for information and assistance in terms of public procurement, as if the act was fully proclaimed. You wouldn't see it in the newspaper, but a number of public bodies would have reversed decisions in terms of awards. They would have pulled back on some contracts that they have already awarded and then realized they were in breach. And they pulled it back and reissued the tender. So some of those things you are seeing on the newspaper. If you open a newspaper any day, you'll see it watched with advertisements for procurement activities.
That is true. Okay, and the reason is because everyone is moving into this mode of let's ensure that we are in compliance with the requirements of the act. Okay, that's
Aleema could have mentioned that they are becoming more and more compliant.
Yes. All right. So I also want to remind our persons, if they have any question or comment, we would be happy to include them in the chat now, so that there is a clarification in the minds of everyone with respect to where they're at the moment. So just to come back to this point, in the event, let's say an organization does not register with you, but they are currently providing goods and services, or they are in the process of responding to a bid or tender, would that continue to hold?
Yeah, let me just tie that in with what is required under the Act in terms of the Central Tenders Board. With the full proclamation of the Act, the Central Tenders Board goes away. Now, the Central Tenders Board is not stopping its business. So you will have tenders in different stages going to the CTB. And we are presently working on a transition plan to transition out of the CTB back into the OPR and the Ministry of Finance. So we have active discussions going on. So it doesn't stop the process from continuing. So we are encouraging the suppliers and contractors to continue to do what they are doing. If they have to pre-qualify, continue to be pre-qualified. If they have an active tender, we have already worked with the Central Tenders Board not to stop the process. Whatever is on stream with the process, that must be continued, because the intention is not to, in full proclamation, everything falls off a cliff and everything comes to a dead halt. That is not the intention. So we are working with all the stakeholders to make sure there is
Seamless integration.
We can't shut down operations at all.
Okay, very unlike our normal CCGI audience, I find that our participants today are relatively quiet. So I want to ask them whether anyone who is participating today has started that process of complying with the procurement regulation, who have started putting their information at with the database at the OPR, and what their experience has been like, if there were any areas that they would have needed clarification or assistance. Anyone at all? Because I know we have several companies present here with us. Okay, so it's either one of two things here, Mr. Lalchan. Nobody.
Problems. We have no problem. So let me just, as you have raised the question, Kamala, we have had upwards of 500 requests through our help desk during the process of getting registered. So we did have a number of persons reaching out through the help desk. We have a turnaround of 98%. So we have answered 98% of those queries. So we do have an active help desk that deals with that. As soon as it comes in, it is resolved within a certain specific time frame. If we can't resolve it within a certain specific time frame, we reach out to the supplier and contractor and give them the information why it's not being addressed, and we are doing more research or anything like that. Coming out of that, the request and so on, we have had 2 amendments to the database already, and those have already been uploaded to production.
Okay. So that's very good information as well, that there's a very active help desk that if anyone, when they're in the midst of the process, need any clarification, that it can easily be resolved. And I am happy to see that we have some comments in the chat from persons who said they have not yet started their pre-qualification with you, but after today's session, they now will be able to engage that. That's excellent. So I was dependent a lot on persons coming with their questions to interact with you, Mr. Lalchan, in terms of what they may need to know of any particular concerns. But it appears that we have dealt with many of those very effectively, because we don't seem to have any questions or comments from the majority, but we do see Saron has her hand up again. So Saron, do join us.
Yes, thank you. I made one note during Mr. Lalchan's presentation concerning one of the objects of the OPR is to investigate claims of corruption and whatnot. So in terms of that, what are some of the protections for the whistleblowers? If a complaint does come to the attention of the OPR, how are the whistleblowers protected, which I think that's absolutely important in cases like that.
All right, so what we have done is actually set up a whistleblowing facility that is outside of the country. So that's the first thing we did. It's not local. There's no local provider involved with them. So it's out of Canada, and there literally is a Chinese wall between that provider and what filters from there to us. So if the person wants to be anonymous, they can be anonymous. I can tell you so far, the act is not proclaimed. We have had 26 complaints for investigation. And not one of those were made public, so you don't even know what is taking place with those 26. So 26, and they would have been reported. We did our preliminary investigation. Reported it to ministers, the line ministers, permanent secretaries, and some went straight to the Prime Minister. So because we don't have the powers to investigate right now, that's how we have been dealing with it. And none of it was in the public domain. So we have strict mechanisms in place that I don't want to divulge in terms of how we go about protecting our whistleblowers. In fact, from setting up anonymous emails, account, and so on, to deal with some of those issues, to upload and download information, all that is part of the whistleblowing facility. So it's a very rigorous process. And we want to make sure that whoever comes forward is protected as much as possible. We do have a full-time crew that deals with investigation and audit, very senior people. We also have under the Act, if we don't have the necessary expertise internally, we can go to outside sources to get expertise. So one of the things we will be, in addition to protecting the whistleblowers, we have to protect our audit and investigation officers who are in the front line. And for the really high risk, high value, complex investigation, we will be bringing in forensic accountants that will be able to come in, do the investigation and fly back out. So all those have been taking place. I could also let you know our audit and investigation team, together with our board and management, have been trained by 10 of the senior judges in Trinidad. The judiciary, 10 judges actually was involved in training us, and 2 from the Caribbean Court of Justice. And we are very grateful for that kind of training. So it helps us to investigate how we deal with case management. We also met with the Commissioner of Police in terms of protection. We went to the DPP. And one of the questions that came out, so what about the disqualified suppliers and officers? How would you be able to find out if they come and register a new company and so on? Well, we do have a relationship also with the FIU. So we will be looking at, and we have meetings and agreements with all the security agencies and so on. I can't go into details, but all those have been taking place in the background, and we have set up memorandum of agreements and so on to deal with it, because one could imagine once this gets going, we'll be stepping on some big toes. And therefore we need very, very mindful of the implications to the staff and members of my board and other stakeholders in this thing. But because this is really mind-boggling to undo 59 years of bad practice in one good sweep, and the implications of stepping on the wrong toes, what could happen in our country. We all know what is happening right now.
Do you all have the powers to fines or any sort of enforcement powers? Do you have those?
We do have enforcement powers. In fact, under section 6.1, we can nullify contracts and make them void. If we find corrupt practices, we take it to the DPP. The fines range from, as I mentioned, 5 million and 10 years in prison. So it's a custodial and a fine. So it ranges between 500,000, 1 year in prison, right up to 5 million and 10 years in prison for different levels of infringement of the Act.
Okay. Thank you. Thanks.
Thank you, Saran, so much for raising that point, because of course it is a very critical area as well, as we seek to bring this change to how we do procurement here in Trinidad and Tobago. So, and thank you very much to Mr. Lalchan for that very detailed explanation as to the process, how it works, so it can give some comfort to persons who want to help participate in the process to ensure that the system is working the way it is now designed, so that we could reduce corruption in our public procurement practices. Now, there is a question in the chat, but just before I go to that question from Francis Hayes, I also want to point out that persons can find the link to the depository in the chat. Mr. Lalchan has posted it there for everyone, so that you can get access and immediately begin filling out your information, so that you could begin the process of qualification. So we go to the question from Francis Hayes now, and she asks, you have stated that companies that are disqualified cannot try to circumvent the system by registering a new company. However, if this is done with new or different directors, how can the OPR ensure that it is the same company in a different form?
Well, once you have common directors and the directors have been disqualified, we'll pick up that very quickly because we could cross-reference it very quickly. We also have a link with the Registrar of Companies and also the Financial Intelligence Unit. Now, the area of, I think, weakness that we see in it is that where they don't actively participate as an officer or a director, but they fund the company in the background.
Right.
So you're not a director, but you are a shareholder and you're a silent shareholder and you fund the company in the background. It's going to be difficult to trace. That's where we are hoping that information like from other sources will help. And also whistleblowing will be very critical. It is even going to be more difficult to trace those funds and so on. So that is some of the weaknesses that we see that we'll have to be working with. But once they are named and we are able to cross-reference, we will then take the necessary action.
Mm-hmm. Okay, Francis, did that answer your question? Yes. Okay, great. Because that generally is the way in which persons try to avoid compliance with some things. They simply shut down that company and they start a new one. But here you will be working with the actual names of the individuals as they appear. Okay, so I see a hand up from Candace Braffett. Candace?
Hi, good afternoon all. A quick question on our end. So moving forward, is it that we should, our company, is it okay for like what the company name or no? Well, I mean, the registered Massey should be registered under the OPR because we do a lot of business with the government, as you all know. So I just wondering, because we do have, where we do tenders for the hospitals or for other government facilities. So we will, what I would like to know is it something that we should probably register under? Because I mean, we have other tenders that we have with certain facilities. Is it something that it must pass through the OPR or it don't have to?
Well, as I mentioned before, under the regulations of pre-qualification and pre-selection regulation, it says that all public bodies shall only use suppliers and contractors that are registered on the OPR's database of pre-qualified contractors and suppliers. So moving forward, you have to be registered. Now, I'm glad you raised the question. So what happens when you have an active tender that you don't have sufficient suppliers and contractors on the system? You are now required, and it's stated also on the regulation, it allows you to go ahead with the tender, open tender, and at the same time invite suppliers and contractors who are not pre-qualified to come into the system in parallel with submitting their bids and be pre-qualified. So at the end of the process, you will have an application in for pre-qualification and the supplier is able to send in a bid even though you're not pre-qualified in an open tender, but you must make the application for pre-qualification. So the public body will, while they're reviewing the tender, they're looking at the pre-qualification. And if you are pre-qualified with all the box ticked, then you are able, your bid will go through. If you are not, and you haven't rectified it within the closing date, then you will not be able to participate. So there is an opportunity, even though you're not on the list of pre-qualified contractors, to get pre-qualified during an active tender.
Thank you so much. Thank you.
You're welcome. Another good question from Johan or Johan? Johan Merritt. Yes, very good question. And that is a question that comes up off and on. So if the supplier have been delisted and the officer has been delisted, and that officer also shares directorship with another company, and those companies that they share directorship with have active contracts in place, what happens then? Well, there is a way that you can apply under the regulations to continue using those suppliers and contractors and continuation of the contract under those circumstances, and it's something that will be brought before the office to make an adjudication. But we would not just disband every single organization. What we will do is to notify the active organization who are performing well of the issue that has been faced with that particular director and give them the opportunity to rectify the situation.
Yeah, that's an excellent question, Johan. Thank you so much for raising it. Because we do have a lot of cross directorship and so on, and there's a likelihood that a situation like this can arise. Yeah, so just for the sake of everyone who may not have seen it, the question was, if one registered entity is disqualified, will that disqualification affect other registered entities who share a director or officer with that entity? Right, and as Mr. Lalchan has indicated, normally it's not automatic. They would in fact advise other entities which can be so affected, because everyone should want to know whether their organization is being placed at risk because of something that has happened by someone who is a related party to them in some way. Yeah. So it started pouring rain here, the way I am. So in the event you were hearing that extra noise in the background, I was trying to mute my mic, but then I forgot to unmute it. So I hope everyone is hearing us very clearly. But of course, we are heading close to our 2:30 time for when we were going to end the session. I thought that this was really very useful. I have sat in on several sessions with Mr. Lalchan already, and so I know just how robust not just the legislation itself is, but in terms of how the OPR has set up systems to ensure that we really try to move in that direction to get the outcomes we want, which is a well-functioning procurement system for Trinidad and Tobago, so that we could reduce a lot of the corruption that we hear of that is impacting how goods and services are being delivered to the public. So if there are no questions or comments again, let me just see. Oh yes, there is one from Aleema Mohammed. And just before I go to Aleema's question, I'm seeing the survey link that Christy has put in the chat. And so I'm going to ask everyone, please go on the chat and click on that link and give us some feedback in terms of your experience with today's session. We always ask for this feedback because it helps us to ensure that we are meeting your expectations. So the question that we have from Aleema is that pre-qualification for published tender from time to time see submission from international as well as regional organizations submitting a bid. Do you think that this can lead to reduction in the ability to benefit from an open and competitive market?
I don't see any reason why it should, and I'll tell you why. Most of the times when we go for international bids, is because when they are successful, you don't have the capacity locally. But we want to make sure that it automatically does not go to a foreign company where you have the capabilities locally to make sure that there is a very level playing field. And you have an uplift now in terms of the local content. So I don't think it will diminish anything at all from the open bidding. It only means that where you have the local content and they are able to justify the local content, you get an added advantage, but in some cases you may not be able to. And then you have a number of local companies who are agents of foreign companies. And they, as local companies with the foreign companies, the partnership allows them to benefit from some of the thresholds and so on. So all those are things that you'll have to measure to really look at the competitive nature of open tender.
Mm-hmm. And it certainly in some ways should encourage our own organizations to up the ante in terms of the quality of work that we offer to ensure that we are providing the best possible goods and services to our public. All right, so it is 2:17. We could begin our wrap up now. I see that there have been quite a few comments in the chat, Aleema. That is thanking you for your very excellent and informative presentation earlier in this session. So I want to ask if we could begin a wrap up, and we'll start with you with some closing comments for today.
Okay, I would just like to say thank you again, Kamala, for the opportunity to present this afternoon. I would also like to say thank you to Mr. Lalchan. Certainly very informative presentation, and adding another layer of compliance for companies in terms of requirements. And I would also like to specifically congratulate the OPR. I mean, in terms of being able to get to this stage, get to this point, in terms of giving effect to the intended regulations even before the proclamation, and to be able to, you know, have the success that you all have been able to. I'm sure it would have taken quite a lot of work and dedication by the team. And I just want to say congratulations to you all. And thank you very much for the information this afternoon. So thanks again, Kamala, and thank you very much to the participants this afternoon. I hope that I've been able to provide some information, which I think did segue into Mr. Lalchan's presentation. So have a good afternoon, everybody. Thank you.
Yes, thank you, Aleema. It was, in fact, a very good opening context that led into why it's so important for us to be ensuring that we are compliant with procurement as well. So, Mr. Lalchan, let's hear some closing remarks from you.
As always, Kamala, it has been a privilege to be part of the discussion. And what I would suggest, if Aleema shares her presentation, that sets a really good foundation to segue into the OPR and public procurement. You would not believe it, but that's very critical in terms of the governance and some of the issues that companies will be dealing with in terms of giving effect to this legislation. So read those two documents, our presentation and Aleema's one, and you'll see the similarities and how much closely they are linked together with all the public bodies and private sector. So these are the requirements in terms of the act, but the structures that you have to put in place is spot on with Aleema's presentation. So I really congratulate her for setting a really good foundation. I was able to float on that foundation very nicely in my presentation. So read both together and you'll see how much benefit you can gain from both presentations. So thank you very much again, and thanks for all the questions. Keep in touch with us, guys. Don't be a stranger. We're always there to help you.